When I was doing my dissertation on negotiation, I came across an author who said that negotiation is not something that you can teach another person to do, and that whether we all like it or not, we are all participants in negotiation because the world is like a giant negotiation table in front of every one of us. And that negotiation is very important because we live in a world where it's not possible to say that conflicts will not arise or exist amongst human beings. And because these issues will always be there, you need negotiation as a tool. So I'm saying this because as human beings, whether we like it or not, nobody will say that he is not participating in commerce. You're either buying or you are selling. You're either going to somebody to buy from the person or somebody is coming to you to sell something to you. I always believe that if you know better, you will do better. There are situations we find people argue and you're like, this is not supposed to be. You're thinking to yourself, I'm like, does this person not know that this is what is required to be done? You see some people in commercial transactions or commercial relationships with each other, and they're arguing about something that they ought to have streamlined from the beginning. So at this point, I now understand that they didn't know better, or they misunderstood it. For instance, in my previous video, I was talking about offer as one of the ingredients that can make a valid contract. But you must also be able to understand whether what you have made is actually an offer. I mentioned in my previous video that there are circumstances that may arise and people misinterpret them to constitute offers. Meanwhile, the law is not viewing those things as offers. An example is an invitation to treat. So I'll be talking about this invitation to treat using 4 different scenarios. But today let us consider somebody who is involved in an auction. You know that when you engage in an auction, there is no one person that can lay claim to the object that you people are bidding for. And the fact that you attended or you are in that auction or invited to attend that auction does not constitute a contract yet. Now, when the auction has started, the persons who are now bidding for that product, whatever that item may be, that moment where you are pricing that product or that item is termed an offer. So the person who is pricing that product at an auction is attempting to create a contractual relationship with the owner of that product. So when you have priced to the satisfaction of the person who is conducting that auction, and he goes ahead to accept it, it means that you have now created a contractual relationship with the person. Right? So whatever happens from that moment where you price that item and the person accepts it, should either of the parties fail in fulfilling the terms, the agreements, covenants made between the both of them, the other party who has been wronged has every right to seek redress. Why? Because there is now an existing contractual relationship between them. I hope this makes sense. This is Xavier Law Essence, where we give you premium legal tips to help you make informed decisions, live informed life, and discover the best version of yourself. See you again.